Item number 8 is a RFA 2/2016. The appeal is stand dismissed.
Item number 9.
Item number 9, criminal petition 02/2021. Here, the criminal petition stand dismissed. The petition. Revised.
Item number 10.
Item number 10, criminal petition 110. Here the petition is allowed and the cognizance order as well as the criminal proceedings stands closed. Petition is allowed. Your criminal petition is set aside and closed.
Item number 11.
Item number 11, MSC 01/2023. Here appeal is allowed, obviously, but though appeal is allowed, it is remanded back to the learned member MSC to calculate the award calculation.
Remanded.
Item number 12.
Item number 12, criminal appeal 14. The appeal is allowed and judgment and order dated 23/3/2023 filed by special judge so and so it's just dismissed and the appellants are acquitted of all charges.
Okay. Item number 13.
Item number 13, no one is here. Item number 13, criminal petition 94/2023. The petition is dismissed. Okay, Ruby.
Mayor, your lordship, lordship, I beg to mention an unlisted criminal application, your lordship.
No,
This-
nothing.
there is
we
an
cannot-
urgency, Your
Cannot list anyone, anything. today. I have already intimated. Friday cannot list.
Your lordship, the prayer is very small. It is only for calling of the LCR, your
Huh?
lordship. Only to call the LCR.
So what
because
is the urgency? Only to call
There
the
is an
SC?
urgency because the matter has already been settled between the parties, your lordship.
So we are not going to settle the matter today. I'm
Yes,
not going to
only
pass
for
any
the
order.
issuing of the notice and if LCR can be called for your lordship. That's all.
Because I'm having bench every principal seat also.
I will take only five
So I
minutes.
don't have any time.
Your lordship, may I please, your lordship, I'd like to mention an unlisted item, your lordship, bail application, your lordship.
No, no understand.
Only for CD, your lordship, only calling for CD, your lordship, only for calling CD, your lordship.
Why you keep pending for this? Yesterday you could have filed.
Yes, your lordship, but
I
there
have
was
all the petition
some
yesterday.
discrepancy, so. Only.
I beg to mention item number 1. Order.
Yes, it was a criminal revision.
Yes, yes, Lord. Here we need 2 weeks time to file some additional affidavit
You are for the
petitioner.
Which one?
additional affidavit.
Item, I'm there, madam.
Item number?
I'm the petitioner for petitioner.
Oh, please check if it is any. Item number, yeah, as per our list is the criminal revision petition. Is there any confusion? As per our list, criminal revision petition 18/2023. You have been engaged here? Then yes,
As per course list, Your Honor.
Huh?
As per course list, it is
yes.
item number 1.
one.
Inva Pertin Kalo.
The court one is not sitting today.
No, it is written code to your lordship, post list.
No, please tell us the number.
Number is lordship RSA 4/2022.
No, not listed.
Okay,
Please check the date and all.
check is 11 your lordship.
Pardon?
Date is 11th.
It's not listed here. Please receive, confirm with the receipt. If it's listed, then I'll take the matter. It's over.
Yeah.
Otherwise, one. Criminal, in our list, criminal division.
May I please lordship.
Yes.
This revision is filed against the criminal appeal number 1, the appeal that has been we have the learned session court upheld the trial court's verdict. Lordship, I will just, it's Friday, so I will just shorten 2-3 minutes, so I will complete it. Lordship, I'll just take your lordship to page 15, paragraph 4. This is the conviction of the learned CGM. Learned court CGM supervised judgment and order.
It was a case under section 352-487.
Yes,
Sorry,
ma'am.
387.
387. So, basically, the conviction was 2 years under 387. Lordship is aware, this extortion, putting someone into fear and then extorting. So, I'll take the only statement of the victim only. So, Lordship may kindly. It's on page 48. So, Lordship, I'll just page 49, the cross-examination what he stated. In cross-examination, Aga Nampa, he is the revision petitioner here. Aga Nampa came to my shop only on the day of the incident and not prior to then. Aga never asked money from me except for assaulting and chasing me. That's all. Except for assaulting me, Aga Nampa never asked money from him. So, the question of extortion doesn't make out it in the entire case. He is the victim. He is the main eyewitness. What happened? He says no money was demanded from him. And to the other person, but he says, June Rakhya never assaulted me or intimidated me. It is true that June Rakhya frequently asked money from me as a help, but he never intimidated me. It is not true that June Rakhya and Aga Nampa frequently created disturbance in the Pangya complex. So, both of the accused persons were charged under the same section. The conviction of the other accused person was 2 months only. Here, I've been convicted for 2 years.
He was convicted under which section then?
Same section.
He is convicted for 2 months.
Yes. The other accused person, therefore he won't come. So I've been convicted for 2 years. That's why I'm before this honorable court. So in this case, notice may be issued, LCR may be called for. Conviction could not have been 387. There's no material in the entire other witnesses also. I'm showing only the victim's statement. So in this case, notice may be issued, LCR may be called for. In other
Since there are two other respondents.
yes, sir. We'll take steps.
Heard Mr. P. Please, Mr. P. Tapo, the learned counsel for the petition, and also heard MSL Hage, the learned additional PP appearing on the state respondent. This is an application under section so and so 20 against the order to take judgment of it so and so, right on this. Giving the submission made by the learned counsel for the so and so. Issue notice to the respondents. However, the respondent number 1 is already set here, and no need to issue so and so. To register AD, and as usual process also call for the LC. Let the matter be listed after 4 weeks.
Yes, ma'am. Malad, in this matter, Malad, we have filed this application, Malad, for 389, Malad, suspension of that order, Malad.
So
That's all.
that may be considered next.
No, no, Malad.
After coming,
Mm.
after.
That- This
No, the question is, he is behind the bar or he is in?
No,
bail?
no, right from trial, during the trial and after, that's why I've annexed the order, Malad, page 74, kindly see.
No,
Malad.
whatever he is in bail.
Yes, Malad. So he may be allowed to remain on bail, that's all, Malad, we are praying, Malad.
No,
No,
no.
no, no, no. Let the LCB come because they may maybe there may be some objection or may not,
No,
be, because
no.
it is of 2 years of conviction, may
Yeah.
not be. But
No,
we dispose
no.
the matter only,
No, no, Malad, kindly see, Malad, this page 74, Malad.
no, what is the supposed question is there? So your petitioner is in bail,
Yes, Malad.
appeal has been instituted here.
Yes,
So
ma'am.
it has been already informed, so I
Yes.
don't think such kind of urgency is there to.
No,
allow
Malad,
suspended.
that's why I'm showing this order passed by learned convicting court, Malad. What he says is he has given time only for 30 days, Malad. That's why, Malad.
The short date may be given loss, not after.
Malad, this is a not,
Short date will not,
No.
on the service of notice
Yes.
will not do, na, short date. will-
this is not a heinous crime, Malad. He was on the bail during the trial after,
No, we are not on that.
yes, Malad.
Yeah, you,
This
Yeah.
is coming lawsuit, it's not so far lawsuit,
Huh?
2 weeks lawsuit.
your date is fixed on how much?
Malad, that's why it was, order was passed on 18/7, Malad. So only 30 days was given, Malad. But thereafter, bail,
Definitely, you can file a petition before the session.
Malad, this is the application for that one, Malad.
Huh?
This application is for suspending the order. Yes, ma'am.
Sciences will, are you ready for?
Then the lawsuit, other party also lawsuit, nurses may be stop lawsuit because IA lawsuit at this stage lawsuit. Up to, I have to go through all the records also lawsuit. Because they say that it is like a suspension is lawsuit, upheld by the session also lawsuit. There must be some.
I
ingredient.
after 1 week then, on,
No, no, it will expire in 2-3 days, Malad.
so we have come very lately then.
No, Malad,
No, why not?
18/7 it was passed.
No.
On 18/8 it will be, Malad, over. Then it may
No,
be
you
fixed
come
on,
lately,
Malad,
when you file the petition after around 20 days or 25
yes.
days. Why?
Malad, Malad,
Now you're showing urgency.
Malad,
But
Malad,
this Section 387 lawsuit, it is a.
it may be, Malad, there may be,
Imprisonment is 7 years lawsuit, but here they give us 2 years lawsuit. It's a leniency already.
it may be
given
fixed
lawsuit.
on 16, Malad. We'll argue on that one, Malad. Because, Malad, she says she's not prepared, but let's argue that on,
16?
yes, Malad, it may be fixed on 16.
I
because today
fix
they are-
on 16.
Yes,
Can we do two orders? Huh? No,
16,
Can be.
16.
I is fixed 6 on 16.
Because there's paucity of time, Malad, that's why I didn't want to take, Malad, show the entire record, Malad, that's why.
On 16. The other way also, you may be allowed to remain.
Yes, madam.
Because the conviction is for 2 years.
Yes, that's why, Malad, it's always, Malad, such, except in heinous crimes, Malad,
Right.
it's always allowed, Malad. How much of it?
Like,
Man, yes. This matter is with regard to this payment of admitted pending bill.
Payment of
Yes,
pending bills.
pending bill. In this regard, kindly see lordship, the issue involved in this case is I have constructed this contract work on compensatory basis over my land because there was a blockage over this main road and the road has been diverted towards my land and the authority has accepted me that I should be appointed as contractor and to execute the work. Accordingly, as per there's a direction of this authority concerned, I have executed all the works and in work
Now
order.
you're all, after the
Yes,
construction,
work-
your bills are held up.
Yeah, bill. And accordingly, bills has been prepared. Then when I place the bill, authority place the bill before the competent authority. And they say there is no fund is available. No fund is exempted, no fund is available. So kindly see in the last, we have issued legal notice, page number 51, annexure 8.
Page number.
Page number 51, annexure 8. As per the reply to the legal notice issued by us, They say that and may I read the contents with reference to it is informed legal notice by certain chairs, which is self-explanatory. The legal notice is served to clear the pending outstanding liabilities of 74 lakhs in connection with the construction of protection work on such and such place in favor of Matung Panya, SP Enterprises. The work was executed through work order basis. Now, the contractor is pressing hard for release of the pending bills, but this office is not in a position to release the payment as there is no sufficient specific fund allotment. Under the above circumstances, you are requested to pursue the method to competent authority for placement of fund so as to release the outstanding due as well as to avoid legal complications. This is the issue. Then, in place of releasing the fund, the department has requested me to pursue the file for placement of fund. This is the issue. That is why since it is already about 2 years and fund is about yet to be released. At this stage, I would pray for this issue of notice to the competent authority.
Yes,
You are
notice,
appealing for comments.
notice may be issued.
So otherwise, you are appealing for
I'm for all the respondents, Your Lordship.
all the respondents.
1 to 4.
Mr. T. Tapak, the Dynamic Council for the petition. Also heard
Arba sir.
Huh?
Arba sir.
Basar, your government.
Yes, Your Lordship.
Government advocate. So for this. This then. This is an application in section 226 of the Constitution of India. Paying for issue of units in nature of mandamus, surgery or any other appropriate fee, or for order direction of that like nature. The case of the petitioner is that after the completion of after the completion of construction work of existing road, the respondent dependent no, your bills are been pending now. After completion of
Yes, after completion,
the bill around 74 lakhs.
74 lakhs.
The payment of bill is still pending of around 74 lakhs. And according to that is present, read appeal has been filed, petition has been filed by the petition. Third, is to issue notice to the respondents. However, the government advocate has already appeared on behalf of the respondent, government respondent. No formal notice is required to be issued. Let the matter be accordingly listed after you need
After 4 weeks,
after 4 weeks. This
extra copies maybe.
extra copy will be served to the respondents during the course of the day.
Yes.
Yes.
May I please announce? My lord, this is a writ petition. Where, my lord, my time bound promotion is not considered, though I have been entitled since from 2013. Time bound promotion is, my lord, that
You're
is,
still in service or
this is, my lord, yeah, medical service.
Huh?
Medical service.
no, you're still in service. Or
Yes.
you got
I'm
retired.
in service.
Still.
My lord. Fact is that, my lord, I am working as a medical officer now as serving as DRCSO presently. My lord, I was appointed in the service in the year 1992. Then after completion of 8 years regular service, I have been promoted to the senior medical officer in 2001. Then after completion of 13 years of service, my lord, I was given time-bound promotion as senior medical selection grade. Then I have completed 20 years during 2013. after completion of 20 years regular service, I should be given time-bound promotion. Time-bound promotion, that is during 2013. But my lord, DPC was constituted in 2021. My case has been left out. I have been not considered. There is, my lord, this is this,
You are not been considered.
this is a scheme, dynamic assured career progression scheme.
DSCP.
In that scheme, DSCP, in that scheme only, my promotion is the grade promotion and then pay financial upgradation. Scale is already fixed there. Therefore, my lord, lordship may kindly come to page 28.
28.
28. This is my lord notification. 28 is a not 28 capital A is type copy. My lord. Here, notification. This was issued on 3 October 2018. May I read, my lord? The governor of Arunachal Pradesh is pleased to accord sanction for grant of 3 financial upgradation to the medical officers of Arunachal Pradesh Health Services under Assured Career Progression Scheme (DSCP) by discontinuing the 2-time bound scheme in the following manners. My lord, this is General Duty Medical Officer (GDMO). My lord, that is A is 8 years, level 11. B is 13 years, level 12. Then my lord, 20 years, level 13. My case is come up in the C. How I am entitled to this? May I take your lordship to page 29? 29 is my lord original copy, not in here. I have annex type copy, that is 38. 38. 38. This is my lord list of eligible doctors who have completed 20 years of regular service allopathy.
So your name is here?
My name is in serial number, my lord, 3. I am Dr. T.D. Namsa. My lord, column 5. That is date of appointment. I was appointed on 7/5/1993. Date of joining as Group A. That is, my lord, 27/7/1993. Then date of first time-bound promotion as SMO. This is, my lord, 28/7/2001. Then, my lord, date of second time-bound promotion SMO selection grade, SG, my lord, this is 29/7/2006. Then, my lord, date of completion of 10 years continuous service. This is, my lord, 28/7/2013. As per this notification, after completion of 20 years, I should have been given, my lord, third time-bound promotion on 28/7/2013. Now, my lord, come to page 31. This is, my lord, notification again, wherein the DPC was held on 5 May 2021. Likely similarly situated doctors, those who have completed 20 years, my lord, it is more than 100 doctors has been given.
But you got promoted on 28/7/2013? No.
No. I have completed, but still I am in the second time bound promotion only. I am mistaken on that. This is, my lord, order dated 21 May 2021. Here, my lord, may I read the contents? Notification. In pursuance of Schedule 7, Rule 7, Schedule 3 of Arunachal Pradesh Health Service Rule 2000, and read with the Arunachal Pradesh Gazette notification number so and so, that the 3 October 2018. On recommendation of the Departmental Promotion Committee dated 5 May 2021, the governor of Arunachal Pradesh is pleased to allow third financial upgradation under GSEPs to the following medical officers from SMO selection grade, allopathy and homeopathy. That is, this is the, my lord, selection list of selection list, wherein I have been left out. Where in this notification I have been left out, in
Well,
that,
your name is on 9, serial number 9.
no, my lord. Herein,
In serial number 9, your name shows in serial number 9.
no, I have been left out in this DPC.
TD Namsa, your name is?
My lord, I am reading page 31 and excerpt 3.
No, 31 is all right, and 36.
Page
your name
30,
shows.
page 31, my lord, and excerpt 3.
Your name is not there.
My name is not there. More than 100 doctors, they have been given third bound promotion
Okay.
in 2020, 2021.
So you are appealing?
Then, my lord, they impugn page 35
Hmm.
and excerpt 4. This is issued by the Director Health Service. Recently, that is on 22 May 2023. Here, my lord, addressing to the Joint Director TNR Bakinpertin Hospital Pasigat, CMS Streams Hospital Naharlagan, DMO, ICR Itanagar Tuang, all Arunachal Pradesh, my lord, district
So,
headquarters.
but here.
Now, here,
for this
subject-
notification, you are being listed, I think, in serial number 9.
Yes.
List,
Here I am-
tentative list of doctors.
Yes.
You are here.
Here, my lord, my name is maintained as seniority in the serial number 19. They are seeking for some documents, whether my name is eligible to be given third bound promotion in the scheme or not. My lord, this is latest issued on 22 March 2023. Now, as per this, my lord, letter, the government is going to constitute an DPC, short limit. This is a proposal. To sit in DPC. Then, my lord, here, as per their documents, my name is here in the list, third time-bound promotion GDMOs, age on 28 to 2022. Here, my name is serial number 9. Now, my lord, just here in this format itself, it is reflected that vigilance submitted in so and so. This is coming in the format, my. So, vigilance clearance certificate ACR is required to be produced before the, my lord, DPC. Therefore, my lord, on Lordship, may please come to page 38. 37 is the application I have sought for NOC from the concerned Deputy Commissioner. That is on 19 January 2016. I have been not given. I have been denied. Then, my lord, as per this present notification letter, this is page 38 is the, my lord, standard application form. And page
So you
30
applied for?
standard application form. My lord, this is I have typed it out in page 38, 39, my lord.
Yes.
A. This
Yes,
is
anything to say? You're appealing for government?
Yes, madam. I'm preparing for 1, 2, and 7, madam.
1,
2 and 7, madam.
1, 2, and 7.
Yes, madam. Here, my lord, notice may be issued, madam, because
7.
come to page, my lord, kindly come to page
And
number
three
41.
is 3.
I'm giving you 3, 4, 5.
3, 4, 5.
Lordship, I am appearing for respondent number 6, land management.
Then,
Yes.
Here, madam, kindly turn to page 41, madam. This NOC
41,
was,
yes.
yes, madam, this one, 41, madam, annexer 7, madam. According to this annexer, madam, since the petitioner had encroached upon a government land and constructed a RCC building, madam, that's why his NOC was not given by the deputy commissioner, madam.
Okay, then we can issue notice.
Yes, madam.
that is not an issue. I have judiciously applied And I have occupied this land since way back in 1990.
Even though
Then
it's a plus
2000
minor, but
2003, I have been given parts bound promotion. Second time bound promotion is given in 2006. And now third bound promotion is objected by that.
we don't know,
Is it-
my lord, whether they have constructed that building in the way back in 2006 or not, my lord. Maybe
I've
he has
not,
constructed now, my lord.
They have been constructed in the government, there's quarter, allotted quarter or where?
No, no, on the
No,
government
you
land,
get
my
that,
lord,
government
land.
That
Heard,
inspection.
Mr. M. Boji, the learned counsel for the petitioner, and also heard, your good name,
T Wang Mung
T. Wangmung, the learned government advocate.
for 1, 2 and
appearing
7,
on behalf of 1,
2 and 7.
And yes, your good name. 3, 4, 5. 3, 4, 5. Standing council.
Standing Council for Health.
For health, no? For health. Yes, for health. Also had Mr. Spencer appearing on behalf of standing council health for. 3, 4, 5, no? 3, 4, 5. And. I'm on behalf of Mr. D. Standing council land management, respondent 6. Also had Mr. Your good name? J. Koyo. J. Koyo, the learned council appearing on behalf of standing council, Mr. D. Pangi for land management on for respond number 6. This is an application so and so. Paying for introduction to pay the substantial financial benefits with retrospective effect from the date of entertainment or for third time bound promotion of the petitioner under DACPS. So and so. It's not hard, issue notice to the respondents. However, all the respondents have been represented by the learned formal council and the other standing councils. No formal notice is required to be served. However, the extra copy may be served to all the respondents during the course of the day. Let the matter be accordingly listed as per you. Do you have read any instruction and all? Yes, ma'am. So after 4 weeks will do?
Yes, ma'am.
Let the matter be listed after 4 weeks.
3 weeks. ma'am.
4 weeks, my lord.
DPC is going to be.
There's no
hot
debt, my
shortly,
lord.
yeah. My lord,
DPC is going to be-
DPC is going to be held shortly. As
But that
proposed.
is not
If
fixed,
you
my lord.
entitled, then you will definitely get if your entitlement is after 4 weeks. They have to take instructions from the council department, I think, so let it. be.
I will-
Like,
4 months. No.
Hello.
Yes,
This is with regard to lordship, the large scale illegal apartment in the respondent department. When you see lordship, I have filed this read petition lordship.
so under
Because
what?
there is a,
Yes, it is a large scale and illegal appointment, so these 3 petitioners, you are 3
Yes,
petitioners. have
we
filed
are,
this
we are
documents.
3 petitioners, we are RTA activists.
Mm.
In this case, can I see as many as 38 persons were, that is in the, have been appointed illegally. And as per the information revealed under the RTI, their services, they were 25 district coordinators. They have only advertised this 12th number of district coordinator. Accordingly, they have been appointed. And above that, 25% of district coordinators in the respondent department have been appointed without following any procedure. Neither they have given examination, nor they have published in the newspaper for this filling up the back and forth. So in this
So
connection,
together 38 appointments were there.
yes, 38 appointments, including this district coordinator. So we have made a complaint to this respondent department, particularly this director and the chairman concerned, who has made the illegal appointment. My complaint is Kindly see. Yes. We have made a complaint by a legal notice to that is illegal, completely illegal, because if such procedure is followed, this is completely contrary to the rules prescribed by law. So
Your complaint is that page? Your complaint is that page? No, you have made complaint before, so and so, no, we are saying page number
page, my complaint is page number 16,
16.
68 is the legal notice
Okay.
issued to the Director of Science and Technology. This is a very sensitive department, Science and Technology, and then there was no response as it is. So we have, who is the guardian of the state, the Chief Secretary? We have filed in the page number 71, annexure 8. We have again filed a complaint before the Chief Secretary, who being the Chief Secretary, who is the head of the administration of the state, and the Chief Vigilance Officer. If there is anomalies, if the officer acted in violation of this office establishment rule, then he can take action against those erring officers. Even then, no such actions taken against this. Neither the Chief Secretary tried to investigate, hold the officer, nor investigate the case, exactly what had happened. And although this large number of posts has been filled up, but which is completely contrary, as I have submitted, contrary to the rules. So at this stage, I would pray for issue of notice to the respondent authority, exactly what the
Criminal cases also, you file any criminal cases in that regard? No.
lordship.
Whether you have filed any criminal case also? No.
No, not yet. I have only filed this before complaint before the
Complaint
Chief
before the-
Secretary, Chief Vigilance Officer. Exactly what had happened. At this stage, notice may be issued.
This is a matter of it. If we should pray for read of warrant of here in this case also. For my understanding, also warrant is issued subject to fulfillment of two conditions also. First process, the persons to hold the office is lack of eligible criteria. And second, lordship, appointment is made in violations of the statutory rules. Here, lordships, the persons who hold the office is not made a party in this case. That 38 persons made a part, challenge the service of the parties. 8% of it.
They were not made.
Yes, not made a party of it. For the reasons that lawsuits, this is the effective petition also.
At
Yes,
this
obviously,
it is
you're
the-
saying that
this-
for they, most probably they should be given an opportunity, the candidates or the appointees, to speak with, I mean, to with their teams, but they are, yes, anything, yeah.
My lordship, my reply to my brother lordship, writ of warrant is, to my understanding, it is this that writ can be issued, that is a discretionary writ of this honorable court. And apart from this praying for writ of warrant, I am praying for any other appropriate writ. And I have also prayed, there is a prayer in my petition that appropriate investigation through Chief Secretary is there. Chief Vigilance Officer comes Chief Secretary. There is.
May I please, Lordship? Lordship, I'm appearing for 1 and 2. Lordship, the petitioner's contention is here is that illegal appointment. So for district coordinator, your Lordship may come to page number 27 of annexure 4 of the petition, Your Lordship. Proper advertisement was plotted, Your Lordship. Accordingly, the 12 posts for the district coordinator, they have been appointed. Your Lordship. And regarding the other appointees, for example, Your Lordship, from annexure, Your Lordship may see from annexure 6 series, Your Lordship, it is in page 30, Your Lordship, may I read, Your Lordship? On recommendation of Department of DPC, the service of Ms. Osanam Lego, District Coordinator on contract basis shall be regular. Your Lordship, according to this order, Your Lordship, the service of the this part Osanam Lego, the particular candidate has been regularized. It is not regarding the appointment, illegal appointment. It is not regarding the appointment. Your Lordship. They have been serving in the department since long. Your Lordship. So it is not about the illegal appointment.
Simply a regularization. order.
Yes, it is, these orders are regarding the regularization. It's not regarding the
These are
illegal.
for 12 coordinators.
Yes, these orders are not for the appointment.
And you are appearing for 3 and 4.
I am appearing for 3 and 4.
So we can do one thing, if you raise the issue of maintainability, in that case, it may be hard. Otherwise, already you have already appeared, so notice issue will be remaining other part, so maintainability may be hard. Or in that case, if suppose he may also get an opportunity to argue in that matter. In that case, we may pass an order to made party the other respondents, they can be made party the illegal appointees or whatever in concerned department also. So you are going to hear the matter. So at present, the matter is, we are going to issue notice, however, the maintainability issue will be hard.
They are the RTA.
RTA petition.
Yes. And even if the post is supposed to be vacant, they are not eligible to fill up this post.
No,
It is
they
the
are
case.
not
The
praying
case.
they are not praying for any eligibility. They are not for eligibility criteria
Yes.
and therefore they are RTA activities.
Yes.
And as per them, it has come to their knowledge that this sort of illegalities without following the procedures and.
Yes,
they will be-
their
That is
contention mainly is of illegal appointment.
That-
Whereas the appointments has been made through due processes. Okay, because Your Lordship, advertisements there, according to the appointments has been made.
I issue the maintainability lawsuit,
Yes.
fix this matter for maintainability.
Yes. Heard Mr. Tita from the Learned Council for the petition, and also heard Sangeeta, no, your name?
Yes, please.
P. Sangeeta, at the government advocate appearing on behalf of respondent number 1 and 2. And Mr. G. Palm, the Learned Council appearing on behalf of the respondent number 3 and 4. It is a recent application, a petition under the article so and so, Ilikidiba, to read on so and so. Against the 38 illegal appointments, including 12 numbers of district coordinator, where the appointments have been made without following the proper procedure of law. In this next place, in this regard, the Learned Council, Mr. G. Palm, it's pointed out that this is a brief petition for warrant, issuing warrant to writ of warrant to, and hence the department, concerned department, and the candidates whose appointment are being challenged should be made party, and accordingly he submitted that this is the petition itself is not maintainable. Further, next paragraph, further submitted by the government advocate, Ms. Sangeeta, MS Sangeeta, that the district coordinator, the appointments of district coordinator were not a new appointments, and only simply their quite order dated 31/1/2019. The order of the district, there was a regularization of service of order of the district coordinators. So there cannot be any illegality or if there and the authority concerned have already issued already regularized the services complying with due procedure of law. Issue notice accordingly. However, the respondents have already been appeared through Learned Councils. No formal notice is required to be served. However, extra copies may be served to the respondents during the course of the day. In the meantime, the matter will be heard on maintainability. Let the matter be accordingly listed. It will take after 3 weeks will do.
Maintainability process.
Yes, maintainability, yes, 3 weeks. Let the matter be listed after 3 weeks. For hearing on the maintainability issue. You just put as a read of warranted over as a amendment, you can verify from record. And whenever you type the order, just accompany the records.
May I plead?
Yes.
Your lordship. In fact, in this matter, the petitioner has got a land allotment in 2016. But then there was a complaint saying that the petitioner has encroached some colony road. So there have been series of a complaint among the private persons who got allotment, who having the allotment in periphery of that colony road. So I'll just, before coming to the impugned order, I will just want to show some FIR and then counter complaint lodged by the petitioner. I want to show that. That's how there's a dispute among the complainant and the petitioners. And then later stage, the impugned order was passed by the state officer. So I'll just take to but I want to just show the allotment order. You all see, it's in page 27.
Page
27.
20.
Yes.
Yes.
May I just from the top, as approved by the government of Arunachal Pradesh, white order such and such, 12 January 2009. Petition name is Nanya Nada, son of such and such, of village Lady Pio Daporijo Circle, Barurijo Uppers district. Is
You are on
hereby
27, page 27, annexure 2.
Annexure 2 is allotted a plot of land measuring 500 square meter for the residential purpose in a plot number 58 at Abotani Colony under Daporijo Township. This land is located in Abotani Colony, Daporijo Township. And then what happens? I'll just show. In fact, I'll just show you that there is some complaint among the other private land owners who have got allotment. I think I will just take to page 30. There was a complaint to the deputy commissioner how the land survey was done by the other person who are not party here, but then who lead the land department, and then they did the survey. I just want to show that who are they involved. You'll also may read just para 2, para 1 and para 2. I am the owner of plot number measuring 500 square meter located at Abotani Colony, Daporijo, being a plot number 58. That's our on 2023 SK Mondal, Tadu Tama and his colleague of land management department, and see the important person here is your lordship is Talen Mangnia. It's just adjacent to the colony road. So there is a dispute between the petitioner and this person. Now the issue here is that this person had encroached some of the area of the colony road, and his allegation is that the land is encroached by the petitioner. This is the disputed fact matter. I want to just bring that this is a disputed fact among the landowners who have been allotted land.
Basically, this is a dispute between the two landowners.
Yes,
But
but
it's a
then
land dispute.
land dispute, but then
So then why you have come with the WBC?
yes, I will come to that, your lordship. There is a plot it's in the colony area. There is a colony road. Now this person saying that this colony road is encroached by this person, and it should be verified by the land department. That's how this person has lead the land department, and they did the survey. And now I'll just read another complaint. I want just read before coming to impugned order. Page 32. Page 32. Page 32. Complaint dated 06/2002/2023. May I read just paragraph? With due respect and humble submission, I have the honor to inform you that Sri Botum Surum, and they are the private respondent here. Botum Surum and Talum Lamdik has entered into my lane digging pit for constructing RCC wall forcibly without my permission and from authority concerned. When I asked them to stop such nuisance in my premises, they want me to stop talking. I, being the law-abiding citizen, without arguing with them, losing this FIR. Therefore, I humbly request your good authority to take action, arrest the person creating nuisance in my premises. But then this was sorted out among themselves, and after that, what happened? My lord have seen the land allotment in 2016. Since the 2016, it's almost 8 or 9 years. There is no any complaint against this petitioner. 2006, since 2016, he is having the peaceful possession of this land, and this land is allotted to him. There is no any complaint. He has built the RCC boundary wall, but suddenly what happened in 2023, which I have read this complaint, the land survey was done, and then the FIR against the other person who are the respondent here, it started in 2023. Now what happened is this, suddenly the impugn show cause notice was issued. I will just take to the impugn show cause notice. Impugn show cause notice in page I'll just take to the show cause notice. Right? Page 34. Page 34. Suddenly in 2023, this show cause notice was issued on the basis of the complaint on the basis of complaint filed by the which I have read the respondents who are respondent here. So this is show cause notice. May I read just first and second paragraph. Whereas it has come to the notice of undersigned that you have encroached upon the colony approach, page 34.
Yes.
Yes. Colony approach road and creating hindrance in construction colony entry road without obtaining prior permission from the competent authority. Whereas a site inspection was conducted by the field staff LM department of Podojo, so once it is which has confirmed the fact of the illegal unauthorized obstruction and objection. Third, whereas site inspection report as mentioned in preamble 2 and attached on with this notice shows that 3 meters in the lane has been illegally constructed and objected by you without seeking any prior permission or authorization from the competent authority. And then you'll also may I just read the provisions, the violation of provisions. Whereas this act of yours in violation of Rule 2 of subclause 4 and 7 of the Arunachal Pradesh Public Premises Eviction Authorized October 2003. And then it says that therefore I such and such Upper Subansiri district in exercise of power vested upon me under section 4 of the Arunachal Pradesh Public Premises of Unauthorized Occupants Act 2003 direct you to show why an order of eviction should not be met within 15 days from the date of issuance of this order. So this show cause notice was issued, and then we filed a reply. And a reply is in page 36. 36. In the reply, what we have said is in page 36. May I read? Also 35, sorry. 35 is the reply of the petitioner. May I just read? First paragraph, that the complaint was made against me for encroaching colony approach road and creating hindrance in constructing colony road. There no iota of truth. Second, the retaining wall and my building staying within the allotted lane and not a single inch of a government land has been encroached. Third, in a site inspection team of the land management department headed by such and such has not measured the land as per the town planning map. They have inspected the site without consulting the town planning map. Therefore, the inspection report submitted by them cannot be said to be the proper verification and inspection, and also cannot be relied upon to pass an order of eviction. So this was the reply. Your lordship, the impugn order, another impugn order was passed in by the state officer in page 36. Page 36. Your lordship, page 36 is the order after the show cause notice and reply. Page 36 is the impugn order passed by the state officer on 15/3/2023. May I just read? where the show cause notice by such and such had served to such and such to so cause a reason of creating hindrance in construction of colony entry road without obtaining prior permission from the competent authority. Where till that you have not submitted so cause reply issued from the office, such hindrance are causing. In fact, there nothing is construction what going on. It's just, I don't know how they made it the story. And then where this act of your is in violation of Rule 2, subclause 4 and 7 of the Arunachal Pradesh Public Premises Eviction Unauthorized Open to Act. I such and such supposed to exercise in the power vested upon me under Section 5 of the Arunachal Pradesh Public Premises Eviction Authorized Occupant Act. So direct you to vacate the premises 7 days from the date of issuance of this order. Let the executive agency to start the public interest work. So this was the impugn order passed by the state officer, and then we filed an appeal under the Section 12 of the Arunachal Pradesh Public Premises Act. There is a appeal provision, Section 12. So we filed the appeal. On appeal was page 37, annexure 4, annexure 6 is the appeal applications we filed. We filed on 22nd March 2023. 22nd, it may be noted, 26 March 2023. So now appeal is pending before the appellate authority, Deputy Commissioner come appellate authority. During the pendency of appellate, application before the appellate authority, again the state officer passed the impugn order dated 22nd and 30 is page 50. Page 50 is the impugn order passed by the state officer.
Yes.
And then 30, another page 51. 51 is also a impugn order passed by the state officer. There's no changes. Just only say that you vacate the land, this and that. So now the state officer passed this two impugn order 22/3/23 and 33/23. So we challenge this before your Honorable High Court. We challenge. And now the page 52 and annexure 7 is the High Court order. The Honorable High Court was pleased to stay this impugn order 30/3/2025 was the stage. No, case is still pending before your Honorable Court. There was it. The stay is there, but then during the pendency of this stay, another the appellate authority, the application which was pending before a deputy commissioner, he passed the appeal order. Is in page 56, annexures 7-8. Page 56. He passed the impugn order when this the matter was pending before your Honorable Court. So may I read just this page 56, the order passed by the Deputy Commissioner from Appellate Authority. In pursuance of the appeal filed by such and such appellant under Section 12 of the Arunachal Pradesh Public Premises, the matter was heard on 18 July 2019, presence of all party. Now here is the respondent, Your Lordship, Sri Talong Mothu, complainant, and representative of Bothum Surup, both are respondent here, along with their legal counsel. The appellant appeal against the order dated 13/3/2023. It is 13/3, but then it was issued on 15/3/2023, passed by the EAC cum state officer of Subans Industry under Section 5 of Arunachal Pradesh Public Premises Eviction of the Act of 2023. On perusal of the record, report submitted by the field staff, land management, branch Daporejo, following observation has been drawn. Allotment-
Your appeal has been rejected.
Yes, my
By
appeal
the
was,
concerned.
yes, my appeal was rejected on 18, and then this was made available to us on 25. Rejection was on 18, and it was made available to us on 25/7/2003. And now the state officer passes another impugn order on 26. 26, and then on the same day, Your Lordship, the respondent responded in this writ petition. The eviction was affected not by the state officer, it was affected by the private respondents. They entered into the premises of the petitioner. They used the JCB, and then they scoped the area, the boundary of the petitioner. And now his RCC building also is in the risk of collapse. It just they scoped they damaged the whole area, and then they encroach upon the boundary of the petitioners. So now question here is whether the third party, the order passed by the state officer, whether right or wrong. In fact, we were not given a chance to challenge before your honorable high court. If you were given a time, you could have challenged. In fact, as per this, even state officer also, he should have given 15 days time as per section 5. It said that minimum 15 days should have been given to the petitioner, saying that you comply this order because appeal has been rejected. You have to comply the order. If not comply, then within that, the eviction will be done by the state officer. That should have been the order of the state officer, but that was not the order. But then this order was not also not available to the petitioners. It was made available to the petitioner on 28, but then eviction was done on 26, same day, done by the private respondent number, my lordship message, private respondent number 6 and 7. So now this is completely illegal, and then it is a criminal trespass. Now we have filed a complaint before the police station. My lord, may I just take up concern here?
Now this one is you have filed this one, the present writ petition because one stay order was there passed by the earlier writ petition.
Yes.
Right. And now this one is for you against this eviction.
Eviction, yes. So we also filed a complaint against the private respondent who did the illegal eviction. Is on page. It starts
It's
on
okay,
page.
and criminal cases.
Yes, yes. So this is a clear violation of Public Premises Act. That is one. Another is that Arunachal Land Record Act, because
That violation of public premises act is against you. Allegation was against you.
against me, yes, yes. But then my submission is that it doesn't comes under the definition of public premises. It is a allotted land to me since 2016, and there has not been any complaint from any third person or anyone saying that there is a encroachment.
If that being so position, then why don't you why don't you approach any civil forum?
Yes,
Because
yeah,
it is a land dispute.
yeah, Lord, yeah, that's what I wanted to just place some judgment saying that when there is a dispute, then the matter should have been before the civil court. I mean, the respondent who has complained and disputed the lane, saying that this is a colony road and this is my lane, then private respondent should have filed resorted to the civil suit.
So they are getting their orders in their favor only from the deputy commissioner.
Yes,
and also
yes,
they
yes.
may not
So
be
that's how it happened.
But if it is a allotted land of your own land, then you could have approached the court. Not
Yes,
by
yes.
any-
But in case, because of that illegal order passed by the state officer, because of that, this has happened. And that also, the eviction has to be done by the state officer who is the authorized person after the public premises.
Yes, you are appearing for,
Lordship will see at page
no, you are appearing for who?
I'm for state, Lordship.
State.
Respondent
1, 2. For respondent,
respondent,
1, 2.
no, Lordship,
No.
respondent, 3 to 5, Lordship.
3 to 5,
Lordship.
6 and 7 on others, and you are for 1.
Lordship will see at page 57, the second para. Now therefore, I suggest the apology power conferred upon me under section 5 of Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2002 hereby such not to make any hindrance in construction of approach road. That's only, Lordship. We have never said that we are going to evict you. We just said that you should not make hindrance when there is construction. And Lordship will see again at page 66. Their FIR, Lordship, to officer inserts police station such and such. Subject FIR. Respected sir, with due respect, I have to honor to inform you that one Sri such and Sri wife of such and such has without valid authority damaged my land using a JCB machine. When I have asked him to stop such, he said the state officer has given permission him to carry out such art cutting. Whereas no such permission or order has been passed by the state officer or deputy commissioner. So Lordship, we have nothing to do when there is a dispute between them. And we have neither authorized them, neither we have given in our order. The
But
matter
they-
is
but they
purely private.
But they came with the order of 26, that eviction order. The private respondent who did the eviction, they came with
If
the.
eviction means they were.
We did not say the eviction order, Your Lordship. We said not to create hindrance. That's
So
only.
how 6 and 7 came to?
Yes, that is true.
Lordship.
How 6 and 7, you did private respondents,
Lordship,
you
that-
are- they,
the petitioner himself has says that there is no permission from us. So we have nothing to do when for their own work.
So now our allegation is there's connivance with the district, the officers
okay, we issue notice.
with the private respondent. That's how they did the illegal evictions. Your Lordship.
Yes. You're appearing for T Panging.
No, Your Lordship, I'm appearing for Mr. D Kamdu, on behalf of Mr. D Kamdu. Standing counsel.
So my prayer is that till I will be praying for the interim. I will be praying for the interim. I think no such construction should be done on that disputed area.
So now see, this is the approach road most probably,
Yes.
which be under construction. During that construction.
But there is a disputed facts. When there is a disputed whether A and B, then they have to make it clear that this particular road is
The
approach
order
road.
was there that your appeal which was filed by before the deputy commissioner was rejected and thereafter an order was issued for directing to make no hindrance in the constructing the.
But we also challenging that because as per this Land Record Act, there is no provision for the land survey which can be done with them. When it is,
Then things will come. later.
when it is allotted lane, when there is a dispute, whether for the colony road or maybe for private land, then first they have to sort out for the civil court. They should have filed a civil suit saying that this is being colony road and this has been encroached by third person.
Now
and
see,
but-
civil suit, they have not referred about file any civil suit, that is their issue, I don't know.
Yes,
But if your, right has been affected by any way, by creating the road or whatever the instance, as you are the best person to approach the civil court because you are claiming that land is the allotted land to you. So your land is there. And
yes.
That is.
Anyway, but the issue here is that eviction, if it's supposed,
Pardon,
it is to be done by, then it has to be done by state office, not by private person.
Mr. Esmond, Learned Council for the petition, also heard. You're for 3-4,
3, 4 and 5. Lordship.
3-4 and also heard your good name.
I
Ram, government advocate.
additional senior.
Additional government advocate appearing on behalf of 3, 4 and 5. And also heard Mr. Your good name.
J for you, on behalf of.
Jay
Mr. D
Foyer
Kamdu.
appearing on behalf of standing council.
For
Mr.
one.
D Panging for the land manager for phone number 1.
1 and 2.
1 and 2. 1. Issue notice to the respondents. Oh, no, sorry. It's next para. It is this is an application under section under article so and so against filed by the petitioner, praying for issuance of a writ of so and so liquidable PPS. Tertiary shall not be issued. Paying to directing the private respondents to not to continue with the eviction process, which is not conducted as per the authorization of the state officer. And more so, it is submitted that one WPC. One WPC 183 2023 is also pending before this court. Which is still pending before the court, but during the pendency of the state writ appeal, the notice for eviction was issued. And on the basis of which the private respondent has started the eviction proceeding, which is illegal and illegal. In this context, it is also the learned government, additional government advocate also submitted that the entire process is have been initiated only on the order of the estate officer, and there is estate of the officer only for construction of the approach roads. of Abotoni Colony, Part 1, Dapojiro, post. Absolutely, you should notice accordingly to the respondents, however, the respond number 1, 3, 1, 2, 3, 4, 5 have already been appeared to their respective councils. And no formal notice is required to be issued, however, the extra copies of the petition may be served on so and so. Issue notice to the private respondents to so and so. Let the matter be accordingly listed after 4 weeks.
Till then, nothing should be, till then, no such activity should be done in that disputed areas.
No,
Because this is,
the approach,
this,
so we cannot,
but the approach we are not disputing, but then,
okay, then in that case, we can hear them
Yes,
complete the petition, then not after 4 weeks, then after 2 weeks. 2 weeks will do.
No, it will take time to get
Huh?
instruction and all.
I'll pray that then the status.
We didn't then take instruction as far as possible because he is urging that the construction road is there. So
I'll-
most probably election procedure is still continue. So let the matter
You're also-
be decided after 3 weeks. Then.
I will pray that at least status quo should be maintained, because my building is almost about to collapse if they further do the cuttings.
Okay, let the matter be listed after 2 weeks. In this matter concerned is regarding the stay of the prosecution will be had. This is the matter after 2 weeks. And the government, government is hereby asked to take instructions, if any, from the government. And the matter will be heard on the steps, matter may be heard on the stay of the execution proceeding. Matter may be heard on prayer of stay, list accordingly after 2 weeks.
Like-
How about-
Today, main
Yes, this is a matter before most probably. It was due to paucity of time matter could not be heard.
yes, ma'am.
So can it be fixed on Monday because he is dealing with the matter? So that's what I'm saying. It is a matter of for part advertisement or staying for so and so, no? Advertisement.
Yes, madam. Issue is, my lord, very simple, my lord. If my lord, very simple, my lord. What, my lord, in the,
Can it be fixed on Monday?
my lord,
I want to fix it on Monday.
Monday, my lord, is the last date, I mean, is the last date for submission of the application, my lord. For advertisement, my lord.
No, whatever. Because matter is there, he is dealing with the matter, so.
Otherwise, my lord, let,
Later Monday.
if he, whether
Yes.
he's.
Yes, matter can be fixed on Monday.
Monday can be fixed. Okay, because he is dealing with the matter, I know that they are regarding the, I have gone through the file, but I thought that should be dealt by the other. company. So let it be fixed on.
IE, my lord, was never heard, my lord, in this case, my lord. IE was never, as here, other side remind, was absent, my lord. Accordingly, matter was fixed on today, my lord. IE was never heard by the earlier judgment. Anyway, my lord.
Then you read Monday.
My-
List on Monday.
Obviously,
Monday is 14th, I think. 14th.
14.
You are from here or?
I'm from respondent.
No. You're from Arunachal or?
Yes,
you're-
I'm from.
Or from Arunachal.
Yes.
Then it's okay. I thought that you have come from.
Obviously,
Okay, after some time, I have actually matter with Honorable Chief Justice. So it will be through, I will be virtually present there. That is the issue. Otherwise also I'm being airy manner because I want to go on to 2021 days I'm here. So that is other aspect.
obviously.
Your Lordship, this is a bail application filed by the accused father, Your Lordship. Accused father,
Father,
yes, Your Lordship.
yes.
Your Lordship, he has been in judicial custody since 6/4/2022 in connection to Chimpu PS case number 18 of 2022 under section 302(201) of IPC, Your Lordship.
This is an BA or an BA?
BA
Since when he is in custody?
6/4/2022.
6/4,
Yes, sir.
6/4.
Yes, sir. 2022.
Hmm. So
Lordship,
now any submission? Yes. from
Yeah,
your side.
Your Lordship, as a charge, it has been charge sheeted, Your Lordship.
Case has already been charged.
Yes, Your Lordship.
It is pending.
It's pending evidence. It's in evidence stage, Your Lordship.
Evidence says
Yes, Your Lordship.
6/4/2022.
Yes, Your Lordship.
Oh, is in evidence stage.
Yes, Your Lordship.
So how many evidences are already been recorded? till now?
In total, there are 42 witnesses, Your Lordship, but out of them
42
only
witnesses are there.
42.
Oh,
Or out of them, only 6 have been examined. Your Lordship.
examined. Achha. So have you annexed the earlier rejection order?
Yes, Your Lordship. Your Lordship, it is in page number 18, Annex 4, Your Lordship.
Now, this is the order passed by this court.
Yes, Your Lordship. This is
In year
subsequent.
2022.
Yes, sir.
Thereafter, have you filed any petition for bail application before the learned court below?
No, Your Lordship.
Why? Why you have not filed any petition?
Because Your Lordship, the Superior Court have rejected the earlier.
It is time when it was rejected, I think. In that time, because it is order is passed on 12/4/2022.
Yes,
So by that time, I don't know whether charge sheet was filed or not. However, charge sheet may be filed, but they may be in the initial stage also. So at least what we can do. We can-
Your Lordship,
Yes.
So then, we have to call for the LCR, scan copy of the LCR then. It's already been charged and the trial is going on. Otherwise,
Because
it's,
why I'm asking you that whether you have filed any petition before the learned court. Before learned court, there will be an observation whether his custodial detention is still required. Because of there may be possibility that kind of observation may be made by the learned trial court. But if you have not filed any such kind of bail prayer before the learned court below, then it will be obviously we'll have to go through the entire record.
no,
Yeah.
sir.
Otherwise, we are not in a position.
yes, sir.
So that is the issue. Otherwise, if order would have been annexed, which has been, even if you file any petition before the most probably there would have been any order passed by the learned court below. There would have been any observation by the learned court below. Because if the trial judge is the best judge to judge whether the detention is required or not.
Yes, sir.
So it was a murder.
Yes, Your Lordship. In the meantime.
Allegation of against murder for who, wife or who?
No, Your Lordship, they are, he's a police officer,
Police
Your Lordship,
officer,
who are victim.
in his resident lawsuit, he's found as death lawsuit, then they are all conspiracy lawsuit, or lots of people involved. And this accused also, as per the allegation lawsuit, accused was also, he was arrested from outside of state lawsuit. He fled away from here lawsuit after committed the crime. That allegation were in the city records in their lawsuit, as per, I have gone to this last objection order. So It's an
So you
evidence
stand-
stage now, that's not so. If, we'll see the record, if it the require, if detention is still required, so our next step bail may be heard also.
Because it is not that he is accused of a bail, I mean murder case, so he won't get bail. That is not the
Okay.
issue. The issue is whether his bail will affect the otherwise.
No,
Yes,
sir.
yes.
Hampering of them, that is the main issue. Because charge sheet has already been filed, so there is no probability of any hampering or investigation still, but however there may be. So at best we can call for the.
LCR.
Heard Mr. N. Rube.
A
You are-
Timu, A Timu. My name is not reflecting. A Timu.
A.
Timu.
Timo, heard Mr. A. Timothy Lanet counsel for the petition and also heard MSL Hagi Lanet petition BP appearing on behalf of state respondent. And again, he did an application section so and so correction, call for the scan copy of the case diary.
LCR.
Sorry, SCR.
Your Lordship,
So we can fix date from where it has to come.
from UPI itself. Your
UPI.
Your Lordship, possible on 4th of September, Your Lordship.
Why
Fourth.
you need so long, long,
Your Lordship, senior counsel will be coming, so
he will be coming on
Eh,
4th,
yes, Your
4th
Lordship.
of September.
Yes, Your Lordship.
Fix a 4th of September. Okay, it will be fixed on 4th of September. Do you have any matter? Do you have any matter?
Yes.
What?
Monday.
What kind of matter? Transfer matter is so urgent.
It will be court one lawsuit, I guess. lawsuit. Because
Mentioning of transfer matter is in court 1 or I don't know. that's
no,
why-
court one lawsuit, because
number.
from Monday onward, court one will be sitting lawsuit.
Okay, then mention you can file on court number 1. If it is a procedure, then the mentioning has to be done before the court number 1. So in that case, you can then give a. For Monday, if you make a mention in the Monday, then maybe listed on Wednesday or the Monday itself.
Yeah.